Peace and love, family. I'm reading this chapter here, chapter 8, from Suits and Chancery. It's the part talking about original bills generally considered. I wanted to read this because this will actually add clarity. We end up in court and we don't understand really what's happening, especially since we have a government educational system. But once we start reading and learning about courts and chancery, common law courts, admiralty courts, and these legislative inferior courts, once we start to inquire more about that, we start to see that the courts are basically there's different jurisdictions. Now let me read this right here, and this will give you a better or more clear understanding of what I'm saying. So this is we're talking here about the original bills generally considered, and I'm going to start off with the section 132, suits and chancery contrasted with actions at law. It says here, a litigation in the chancery court is properly termed a suit, while a contest, listen to that, in a court of law is properly denominated an action. So you see, when you say we're going to bring forth an action, well, that's going to be a court of law. You say, well, I want to bring a suit, I want to sue somebody. Well, that's going to have to go through the courts of chancery and equity. So it says here, the party who institutes a proceeding in a court of law is ordinarily called plaintiff, while he who begins a suit in a court of chancery is generally called complainant. The person sued is called defendant in each court, unless he responds to a discovery in chancery, in which case he is sometimes denominated respondent. In a court of law, an action is begun by filing a bond for cost and suing out a summons. So you see, this is interesting, because the court of law, that's where everybody's taken. The magistrate's court for penal actions. And it says here, look, it says here, in a court of law, an action is begun by filing a bond for costs and suing out of a summons. So when we go to court, the prosecutor is supposed to put a bond in there, but they don't do that. What they do is they bring up the case and then they lock us up until we issue the bond, and then they claim the bond. So that's very interesting. So let's see here. It says here, but in a court of chancery, a suit is commenced by filing a bill. The cost bond not being essential to the beginning of a suit. It is as it is in the circuit court. In a court of law, the first pleading is a declaration filed at the return term, couched in formal and technical phraseology, full of bombastic verbosity and teeming with blood-curdling descriptions of imaginary barbarities inflicted by the wicked defendant upon the innocent and outraged plaintiff. While in chancery, a bill is filed before the subpoena issues and is ordinarily a plain statement in ordinary language of complainant's rights in the premise and of their retention or violation or threatened violation by the defendant. Indeed, a bill would be correctly phrased which described the grounds of suit in the manner and language which one unprofessional person would use in writing about them to another. And such was the character and frame of bills in the early history of the court. In an action at law, the evidence is mainly given by witnesses examined orally in open court, whereas in a chancery suit, the evidence is mainly contained in depositions taken in vacation. In an action at law, the issue of fact raised by the pleadings are ordinarily decided by a jury under instructions by the judge, while in chancery, the issues of fact are ordinarily heard and determined by the chancellor. The court of law regards forms, rules, and precedents, while the court of chancery regards the circumstances of the case, ignores forms, and prefers good reason and good conscience to rules and precedences. In an action at law, the decision is termed a judgment, and it either awards a sum of money or the possession of property to the plaintiff, or taxes to the plaintiff with the cost of the suit, while the decision in the chancery suit is called a decree, and it may not only award money or property to one or more of the complainants, but may at the same time award money or property to one or more of the defendants, or may require a party to do some particular act, or may prohibit him from doing some particular act, and may tax any of the parties with the cost, or may divide the cost among the parties. In an action at law, all property to satisfy a judgment is sold by the sheriff under an execution, and he receives and pays over the money. But in a chancery suit, the sale of property, and especially real property, are usually made by the clerk and master, and confirmed by the chancellor, and the proceeds of the sale are paid out by the clerk and master. In an action at law, an equitable interest in property is not cognizable. You hear that? An action in law, an equitable interest in property is not cognizable. And an equity cannot be levied on or sold. Whereas in chancery, equitable interests are dealt with and may be sold or transferred or converted into a legal estate. See, that's why we have to bring this in equity. You can't go in a court of law and say, hey, I got equitable interest in property. That bullshit. Look, it says it right there. They're not going to recognize that. It has to be it has to be through equity, where equitable interests are dealt with, see? And it may be sold, or we could transfer, or you can assign it. So, let me get back here. And the reliefs the two courts grant are very dissimilar. Courts of law have a distinct form of action to redress each wrong and assert each right, whereas in chancery several wrongs may be redressed and several rights asserted in one and the same suit. Thus, in the same suit, the chancery court may 1. Stay waste, 2. Impound the proceeds of the waste, 3. Award damages for the waste committed, 4. Adjudge the land to the complainant, 5. Give him a decree for back rents, and 6. Put him in possession of the property, whereas a court of law would require 4 different actions and an injunction in chancery besides to accomplish the same result. Yeah, in an action at law, the plaintiff must sue for either property or money, In a suit of chancery, the complainant may sue for both the property and its money value. In the alternative, and if he failed to get the property, the court will, in a proper case, award a money equivalent. In an action at law, you get what the law allows. In a suit in chancery, you get what is just and right, according to equity and good conscience. The law may be right, equity is right itself. Section 133, how a suit in chancery is commenced. A suit in chancery is commenced, 1. By bill or petition, addressed to the chancellor of the division in which it is to be filed, and specifying the particular court in which it is to be filed. Or 2. By motion in open court where the mode of procedure is allowed by law. 1. By bill or petition. A bill is a complaint. Sorry about that. A bill is a complaint in writing, addressed to the chancellor, containing the names of the parties complaining and complained of, and their respective places of residence, and setting forth a clear and orderly statement of the complainant's rights, and how and wherein those rights have been denied, interfered with, or violated by the party complained of, and concluding with a prayer for process to bring the latter party before the court to answer the complaint made, and a prayer for appropriate relief. A bill is sometimes called a petition, especially when filed to obtain. 1. A divorce. 2. A dower. 3. A partition of land. 4. A sale of land for partition. 5. A sale of lands to pay a decedent's debt. 6. The removal of a trustee. 7. A mandamus. 8. A habeas corpus. And 9. An inquisition of lunacy. A petition, however, is ordinarily a written statement made to the chancellor during the progress of a suit in order to bring before the court or the chancellor some matter connected with the suit affecting the petitioner's rights, and not otherwise sufficiently appearing, or to obtain some relief in the cause not otherwise obtainable. When a suit is commenced by petition, the petition must contain the names and residence of the parties, and a sufficient statement of the facts to show that the petitioner is entitled to relief, and must pray for process and for the relief. It says number 6. Let's see what it says here. Number 6. Just this. Okay, so by motion. Suits commenced by motion in the Chancery Court are conducted in a summary way without formal pleadings, the motions being entered on the minutes of the court. This entry is in the nature of a pleading and should contain sufficient facts to give the court jurisdiction and to authorize the judgment. So the entry in the nature of a pleading, so in a pleading we need to put sufficient facts that will give the court jurisdiction and the authorization of the judgment. As, however, all ordinary original suits in chancery are commenced by bill, the nature, substance, and forms of bill, and the practice and pleadings consequent on the filing of a bill will first be considered, and suits commenced by petition and by motion will be treated of hereafter. The party who institutes the suit is generally termed the complainant, because he complains of some wrong done to him. The party against whom the suit is instituted is called the defendant, because he defends against the complaint made. 134. Necessity and object of pleadings. In every system of jurisprudence, some forms of proceeding must be established to bring the matters in controversy between parties before the tribunal by which they are to be adjudicated. These forms of proceedings are devised in order that the litigants may have a fair opportunity of presenting their respective sides of the controversy and to enable the court to determine the questions in issue with accuracy and dispatch. The written complaints made by the complainant and the written defenses made thereto by the defendant are termed pleadings, and to exhibit the present system of equity pleading in Tennessee is one of the main purposes of the present treatise. Such portion of the old system of pleading as are obsolete will be wholly omitted, and much of that which is unnecessary or unimportant may mainly disregarded. 135. General nature of a bill. A bill is a written statement of such matters as the complainant desires to bring to the attention of the court. These matters must be such as are written These matters must be such as are within the jurisdiction of the Chancery Court. That jurisdiction generally extends to the final decision of the subject matter of the suit, but sometimes it is only ancillary to the decision of a suit pending in the same court, or of a suit brought or to be brought in another court. Sometimes it is merely of a precautionary or preventative nature to avert a meditated or threatened wrong. And sometimes it is merely to require that the parties really interested in a controversy should be compelled to litigate their rights without peril or expense to a mere stakeholder having no interest therein. The bill may either complain of some injury which the party exhibiting it suffers and pray relief according to the injury, or without praying relief. It may seek a discovery of matter necessary to support or defend another suit, or it may seek to preserve or perpetuate testimony, or it may complain of a threatened wrong or impending mischief, and stating a probable ground of possible injury. It may pray the assistance of the court to enable the party exhibiting the bill to protect or defend themselves from such wrong or mischief whenever it shall be attempted or committed, or it may relate to some defect in a pending suit in the same court, or may seek to introduce some new or additional matter into a pending suit, or to obtain the benefit of, or change, or reverse the proceedings in a pending suit. Alright. Different kind of bills. Bills in Chancery are of two general kinds: original bills and bills not original. Original bills are those which relate to some matter not before litigated in the same court by the same persons, standing in the same interest and making the same allegations. Bills not original are those which relate to some matter already litigated in the same court by the same parties, or their privies, but which seek to make some addition to, or to obtain some benefit from, the original bill, or to supply some defect in it. There is another class of bills which is of a mixed nature and partakes of the character of both of the others. Thus, for example, bills brought for the purpose of cross litigation or of controverting or suspending or reversing some decree or order of the court, or of obtaining the benefit of a former decree, or of carrying it into execution, are not considered as strictly a continuance of a former bill, but in the nature of original bills. And if these bills require new facts to be stated or new parties to be brought before the court, they are, so far, strictly of the nature of supplemental bills. For all other objects of the present work, this last class may be treated as included in that of bills not original. Original bills. Original bills are divided into those which pray relief and those which do not pray relief. Original bills praying relief are subdivided into two kinds. One, bills praying the decree or order of the court touching some right claimed by the party exhibiting the bill in opposition to some right, real or supposed, claimed by the party against whom the bill is exhibited, or touching some wrong done in violation of the complainant's rights. This is the most common kind of bill. 2. The bill of interpleader, where the person exhibiting the bill claims no right in opposition to the rights claimed by the persons against whom the bill is exhibited, but prays the decree of the court touching the rights of those persons for the safety of the person exhibiting the bill. Original bills not praying relief are also two kinds. One, bills to perpetuate the testimony of witness or to examine witness, de bene esse, and 2, bills of discovery, technically so called. That is to say, bills for discovery of facts resting within the knowledge of the party against whom they are exhibited, or for the discovery of deeds, writings, or other things in his custody or power, and praying no relief on the merits. No, it's almost done. Bills not original. Section 138. Bills not original are either in addition to or a continuance of an original bill, or they are for the purpose of cross-litigation or of controverting or suspending or reversing some decree or order of the court or of carrying it into execution. The former kinds include 1. A supplemental bill, which is merely an addition to the original bill to supply some defect in its frame or structure. 2. A bill of reviver, which is a continuance of the original bill to bring some new party before the court when, by death or otherwise, the original party has become incapable of prosecuting or defending the suit, and the suit is, as it is in equity, technically called abated, that is, suspended in its progress. 3. A bill both of reviver and supplement, which continues a suit upon an abatement and supplies defects which have arisen from some events subsequent to the institution of the suit. Bills not original for the purpose of cross-litigation or of controverting, suspending or reversing some decree or order of the court or carrying it into execution are 1. A cross bill exhibited by the defendant in the original suit against the complainant in that suit, touching some matter in a litigation in the first bill. 2. A bill of review, which is brought to examine and reverse a decree made upon a former bill at a former term of the court, and for that reason not subject to change on the rehearing. A bill to impeach a decree upon the ground of fraud. A bill to suspend I like this one. Wait a minute. A bill to impeach a decree upon the ground of fraud. A bill to suspend the operation of a decree in special circumstances or to avoid it on the ground of matter which has arisen subsequent to it. 5. A bill to carry a decree made in a former suit into execution. 6. And lastly, a bill partaking of the qualities of some one or more of these bills, such as a bill in the nature of a bill of reviver, or in the nature of a supplemental bill, or in the nature of a bill reviver, and others of the like character. Well, that is it for now, but I wanted to share that part with you guys. Again, this is Suits in Chancery by Henry Gibson. But reading this more and more, you'll see that the courts are operating right now, like they say, at law, court of law. And it's obviously a different jurisdiction, different formalities, different procedures, different rules. There's distinction between these two venues per se. And it is obvious that this is not something that everybody knows about, but we're coming to learn about it. And it is very, very important to know that there are two separate venues, at least at the courts right now. So if they bring us into court, obviously we know if it's a court of law, it's going to be in rem, meaning against things, or maybe they are there to enforce a contract, which is a public contract which they're presuming, or it is an implied contract, meaning, oh, you have a driver's license, okay, well, you fall under all these rules right here. And if that's the case, then if we are to convey or assign our rights to certain instruments that can be used to secure obligations that are due into a court of law, and then we need to claim equitable rights, we know that in the court of law it's not going to be recognized. Obviously it's not going to be recognized because it's public. So there needs to be clear understanding, and also the courts, I think it is due to the courts not being transparent about this that is making this very, very hard. And because they're not transparent about this, they're doing something else. Other things has been going on in the background, and it is the manufacturing of bills and bonds, the production of bills and bonds, and utilizing these for whatever reasons in their registry investment system. This obviously, whenever it becomes more and more known, it is going to concern those judges and magistrates, because it is going to be looked upon as very suspicious activities. So that's all for today. Again, this is Suits in Chancery by Henry Gibson. It's right here. The principles, pleadings, practices, and proofs, and proofs, and processes of the jurisprudence in equity, and giving numerous illustrative forms, pleadings, writs, orders, reports, decrees, and other proceedings in suits in chancery from their beginning and their ending. Henry R. Gibson. Peace, love, and law.